When people prepare wills, they do so to ensure that the affairs of their estates are well managed long after they are gone. And in these wills are executors, who are people selected to ensure that the wishes of the deceased are followed to the letter. Today on Law Express, we'll explore the role of the executor and what they have to do to ensure that these wills are acted upon in accordance with the wishes of deceased persons. This is Law Express. My name is Noella Seidu. Do join us on the discussion on probates.
Sebastian Owusu is a private legal practitioner who loves swimming, golfing, and sightseeing. Yao Edenam Kofi, a private legal practitioner, enjoys reading biographies as a hobby. Noella Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
Comes in when a person dies, leaving behind a will. There would be a need for authorization to administer and distribute the estate of the deceased person. And so probate is what you would have to apply for from the court, which will give you that authority. Not when I say you, the executor of the will, to administer the property and distribute it according to the will and law.
So probate basically is the structure, the legal structure that regulates how people who have left wills, their intentions are actually executed, right?
Yes. My big brother mentioned executors. We have to understand that the will comes with, it's named executors. It's not anybody else that can go to court and say, I want to take legal steps to administer the estate of a deceased person. Usually, in drafting a will, you have to name people which would take after you in terms of administering and distributing your estate.
So taking care of your affairs.
Yes.
Executors could also be those required to pay your just debts.
So just debts.
Exactly.
Just debts.
You know, even pass on some information to designated people. For instance, you want your children to know something only after your demise.
Yes.
So you can choose those people and then they have to act on your wishes.
Yes.
So your representatives.
Yes.
After you're long gone.
You're long gone.
Exactly.
So you're dead, you left behind a will, they have searched for same, probably from the courts, from your personal effects. They've established that you have a will. What are the next steps?
If it's established that there's a will, the law requires the executors, as we spoke about, to apply for probate.
Yeah.
Application would mean that you go to court, you appear before a judge. There are certain requirements. For instance, you need an inventory. Now let me go back a little. Under the Administration of Estate Act, you are required to, if you have started dealing with the estate, then you need to do that within a month.
Within 3 months?
That's under the
administration. Yes, under the rules of court, you must do it within 3 months. So there's a difference. In
good. It's good you've drawn that distinction. Under the rules of court, the High Court Civil Procedure Rules, you do that within 3 months. Under the Administration of Estate Act, you do that
within a month.
Within a month.
So where there's a statute coming against rules, I think the statute will.
I think the statute.
So you need to do it within 1 month to be safe.
Within 1 month to be safe. I don't know whether we need to go into the detail of what you need to present.
I mean, probably just briefly. Yes, you cannot deal with the estates without being proclaimed and confirmed as an executor.
Exactly.
Because that's the purpose of the exercise. So people don't lie. So also to let the general public have notice of the fact that you are in charge of the estate. So they've read the will, which is normally done around the courts, in the courts. And you've been named executors. You were talking about applying.
Yeah, application. So you go with motion and affidavit, there are some important information that you need to know: when the deceased died,
Yes.
where he died,
His last
place of abode.
Yes.
And I think as evidence of the death of the person, maybe a death
Yeah.
certificate, sometimes the burial certificate, and people even add
The burial permit.
burial permit, medical cause of death.
report.
Yes.
Some people put the obituary notice too on it.
People as well.
Yeah.
I mean, just for avoidance of doubt, people add that. Then an inventory, you attach an inventory of the estate, the property that the deceased died, both movable and movable, that the deceased died possessed of.
Okay.
I mean, there's an authority to the effect that it is compulsory.
Yeah, it's essential.
Yeah, it's essential. You cannot.
And that's probably why the law allows you to deal with the property at least for a month, to be
Yes.
able to gather for
for-
listing purposes.
Exactly. At least for you to know.
Unless the person just had one thing and everybody
And
knows
everybody
it. So.
knows.
If you had an old car in
Yeah.
elderly property.
Yes, and also, you see, as I said, the executors are named in the will.
Yes.
So until the will is being read, nobody knows who are the named executors. So somebody must step up and initiate the process of going to the registry or doing the searches that is involved to ascertain whether the said will was deposited in there.
So it could be any beneficiary of
Any
the estate.
beneficiary.
You know.
So they normally conduct searches. Yes.
So who qualifies as an executor? Normally people assume that once it's a will, definitely to be your wife and children if you're a male. It could be your husband if you're female, your brother. Must it always be that?
So an executor is being chosen by the testator.
Yes.
He can decide to choose anybody else. But usually people choose people who are younger than them because the will only takes effect
After
after
you
your
died.
death.
Yeah.
So you have to choose somebody, presumably, who will live longer than you,
Who will
Yeah.
not predecease you.
who will not predecease you. Because if the people you choose as executors die before you, it means that the will fall under intestacy. It means you have to go for early letters of administration instead of the probate.
The probate.
You are more likely to pick somebody you trust first to follow your wishes.
Yes.
Somebody of good character, because you don't want an executor who will diminish your estate
That's
and
very true.
rather take away from the people who should benefit.
Yeah, exactly.
Because in that whole administration space, it's not just a simple thing of distribution. You have to gather,
You have to
and in
gather,
collecting, you
collect,
don't want somebody
pay
who will
debts.
steal.
Exactly. Pay the just debts.
Yes.
And
Pay debts, and then
And also
Taxes.
ensure
then taxes.
that the beneficiaries get what,
What
they
they're
are entitled to.
entitled to.
Yes.
Which is-
and within a timeous fashion.
Yes.
Yes.
So your executors now go to court to apply for probate. And there's somebody who feels that, look, probably this will is not legit, or this person shouldn't be an executor for one reason or the other. What do they do?
Before I come to that, I would like to state that contents of will have been a subject matter of litigation. So, and I will entreat our listeners to, or admonish them that if you are drafting a will, you should seek counsel.
Get a lawyer.
Yes,
Lawyer.
get a lawyer.
Yeah.
Because the fact that you've left a will doesn't mean your estate is safe.
That's true.
Simple words can turn into a 10-year litigation,
Litigation. Exactly.
which will, in effect,
Or
diminish
even
your estate as well.
residual property.
Yeah.
So you've addressed some of your property,
And
but
left some.
over time, after you drafted that will, you actually got more valuable
More valuable.
property.
Exactly.
And now you did not include that.
in the world.
A lawyer knows what to do, what
Cover.
words to add to cover that.
Exactly. The fact that you've made a will doesn't mean you're about to die. I think there's a stigma that comes with it. If I've had talks in churches, and if you speak about will, people think you anticipate that they are about to die.
But it's also because of what the will, when the will actually comes to play. We already established that, look, they are ambulatory. They only will come up after you've died. Nobody wants to think about that. So the average person is like, what am I planning for after my my demise? And some would even go to the extent of saying, oh, that's not my business after I'm dead. Allow everybody
Exactly.
to fight over
Just let
it.
them fight.
You can't leave confusion behind.
Exactly.
I mean, it's better.
I mean, it's free money for beneficiaries,
Yeah, that's
right?
it,
Free
yes.
property.
Free
So
property.
naturally, people would be greedy
Yeah, people will be greedy.
because they don't have to work for it.
Yeah, that's true. So if there's a very clear instruction
Says on
behind
how-
that, look, do this, give this to this person, and that's better.
And yeah, it's better, but it doesn't always cure the problem because there are
doesn't.
people who still challenge
I mean,
the validity of the will and even the contents.
the content, exactly. In terms of the language,
Exactly.
they give their own meaning.
Yeah.
To,
Yes.
to it. So that's why my colleague says you should consult a lawyer.
Get a professional,
Get a
right?
professional.
Professional.
Great.
Very
You've made a case for lawyers. Now let's move on to what happens. Okay. After your will has been found, it's been read,
It's been read.
Somebody has applied.
Yes.
You think that something is irregular with the will, either in contents or in the whole will itself. You're challenging that indeed your deceased relative actually prepared a will. What do you do?
So the first step, as I always say, is to consult a lawyer.
Yes.
And the lawyer will file what we call a caveat.
Okay.
So a caveat is that you are disputing the grant of the probate.
Yeah.
That the court should hold on, and that you have a reason why the probate should not be granted to the executors. And so the courts will look into it and either direct the parties as to how to go about it. Either you file a writ or... But whilst a caveat is filed, the court cannot proceed to granting a probate to any executor.
Great. So we can look at it in two ways.
Okay.
So here is the case that somebody who first you must have an interest in that will.
Yes.
So you must be connected to the will or to the person who prepared that will.
Yes.
Maybe as a child,
Child,
a sibling. There should be a relationship such that you feel that you are likely to be a beneficiary. Now, where the will has been read, you know for sure whether you've been listed or
But
not.
If you claim,
Yes.
you can also
So,
make a claim that
so you now put your claim in.
yes.
So once you establish that there's a will, or somebody claims there's a will, and you have an issue, you quickly apply into court,
Yes.
you know, to register your protest.
Exactly.
Or when you hear that they've applied,
Right.
then you quickly get in.
Quickly get-
But if they've already
Once it's
granted,
granted.
it's a different procedure altogether.
Yes. But your avenues or remedies are not exhausted,
Yes.
even
Yeah.
if it's granted, because the likelihood that you will be aware after it's been granted is very high. Because if these so-called executors are in a hurry, they will hide the process from the true beneficiaries.
And do the
Yes.
publication somewhere else.
And go to court. So by the time, a lot of people, by the time they realize these people are already executors with the documents from court,
Exactly.
so your remedies are not exhausted. You can go to a lawyer and a writ can be filed, an injunction can be put on the further distribution of the property.
And the thing with probate is that sometimes they can dispense with the publication, unlike early.
Yes.
So in the case of early, because of the publication, it's easier to find out that
I think it's almost impossible to challenge the mandate of an executor, because the one who owns the property says that I want this person to do this. It's where it's letters of administration that it's easier because you need to agree as beneficiaries that these would be your reps in terms of. But today, since our conversation is not on earlies, we're looking at probate. So the person who drafted this will says that I prefer Sebastian and Edinam to be the executors. How can you, a mere beneficiary, you don't own it, and until they hand over to you, you still can't deal with the property?
So I think
The
the other way
yeah.
they challenge is that,
Yes.
okay, I say Edinam Kofi, I name Edinam Kofi as mine. You are not the Edinam Kofi that our late father is talking about.
Okay.
There's another Edinam Kofi.
Yes.
So that's why we are saying you need a lawyer, because Edinam Kofi of house numbers, also clarity.
Yes.
You just put Edinam Kofi and there are 1,001 Edinam Kofis. I can come and tell you that we are not sure of which
Especially
Edinam Kofi
within the same family.
with the same family.
Yeah. And there's a senior and a
There's
junior.
a senior and a junior, and, exactly. So those are some of the grounds on which they could challenge
The executor's
the executive
mandate.
mandate that you are not the one we think the testator is talking about.
But then most caveats come as a challenge to the content of the will,
content, yes.
where
Yes,
you
most
think
often
that,
they are not.
yes, this is not the proper reflection of things. And it normally comes from people who are entitled and feel that they should have had more.
Yeah, true.
Like, considering how close I was with this person, there's no way he would have left me the old car.
Under the latest car.
And also, I think a lot of people might not challenge just because they feel they're entitled to more. But sometimes they feel the testator at the time of the said will could not have.
Yes.
Maybe due to ill health
or his state of mind.
Yes, anything. Maybe the person wasn't even in the jurisdiction you are saying he was at the time.
Especially when you see the witnesses too.
The witnesses too sometimes.
So the witnesses were in Australia, the person was in Ghana, witnesses hadn't showed up in years.
Yes.
And then there's a will that puts them in the same place, you know, at a time that it wasn't possible.
Even the
Then
signature.
that's
The
suspicious.
signature. Yes,
the
the
signature
signature.
could be.
Yes, sometimes the signatures, people forge people's signatures, especially people who are close to people.
Yes.
And this day and age where we have digital
I mean,
signatures,
it's so easy.
it's so easy to prepare a document
But the
in somebody's
signature
name.
bit, okay, comes to play. Well, the law contemplating this brings the witnesses in for the purpose
Yeah,
because
to
they
attest.
come
Yeah,
to attest to
to-
the signature
Yeah, exactly.
and not the contents
Not
of the will.
content, yes, it's just the signature.
And this is a reason why people shy away from drafting wills. They think that by getting witnesses, those witnesses automatically read your will.
No, they're not reading. They are not supposed to read.
They are not supposed to. The idea is they are just supposed to be there when you sign your will.
Yeah, well, so I
So,
saw
yes,
Noella
that's
signed in.
exactly.
Not the content. They are
Yes.
not
So they
required.
wouldn't know.
Yeah, they wouldn't know.
You know, so if you have any fears that people will know what the contents of your will is beforehand, probably it's just the one who helped you professionally to prepare it, your lawyer, who would know.
And we are under a
And-
duty not to disclose.
Exactly. So you have a
confidentiality.
professional duty to keep that to yourself.
That is true.
So you're safe. Just make sure you have that will prepared properly for you. We'll go for a quick commercial break. When we come back, we explore further the challenge as to signatures and the things that could lead to that.
Okay.
This is Law Express. Don't go away. So with the challenge, that's where we were before. You talked about ill health, and that's very crucial in determining if somebody really appended his mark on a document. Now, you and I know that if you sit to sign, it's different from when you stand to sign,
That's true.
even in optimum health.
Yes.
If you're kneeling to sign or write, it looks different from when you bend over to sign or write. Now, the kind of material you're using to sign also gives different outcome.
That is true.
So, ballpoint pen,
Yeah, ballpoint pen. Yeah.
is different from some sophisticated calligraphy pen.
Yes.
Okay, it will also be different from a crayon, a marker. So, even your state of mind, if you signed whilst in hospital, it will be different. Your age, probably you've started having some medical conditions that make your hand shake. Now, that doesn't mean that all those are not valid.
Yes. Doesn't mean it's not valid.
And that is where the experts come in.
Yeah, we bring in experts, handwriting
Experts,
to
yes.
confirm.
They would have to confirm and they would consider all these factors.
Practice, yeah.
So the fact that it's different slightly from the normal doesn't mean automatically it's an
mean that,
invalid
yeah,
signature.
Signature, yeah.
First, if the people who were there said, look, we're there, he was 90 years, he understood, he signed, we signed, of course, it wouldn't be like his other signatures where he was 40. Because sometimes those wills are revised over time.
Yeah, yeah, right.
So maybe they find an older one and they are seeking and insisting that that is actually
That is the,
the valid and last one.
So the executors are required to apply for probate. Where you neglect to do so, the court on its own, or any interested person who claims an interest, who has an interest or who claims an interest, can apply, would bring you to your notice of the need to apply for probate. if you fail to do so, the rules require that you bring a formal process. And when that formal process is commenced, you need, within a specified number of days, you need to respond.
Yeah.
If you fail to do so, if you fail to respond, either apply for probate or renounce. Renunciation means that, look, you've appointed me.
I don't want to do it.
I don't want to
You
do it.
didn't consult me.
You didn't consult me, or you didn't consulted me. I don't want to
Or
do it.
your family is so complicated that I'll
Yes,
get into
I
trouble
don't
for
have any
helping.
dealing with
to
them.
be
Yeah.
involved with
So,
this.
I mean, I'm not interested. If he fails, if the person fails to either apply for probate or renounce,
Yeah.
then by operation of law, you lose that right to
So your right as an
administer the
executor is
estate.
extinguished.
it's extinguished.
So let's break it down further.
Okay, sure.
There are two categories you have talked about,
Okay.
counsel. So the first category is this person who probably does not know that he's an executor, maybe at the reading of the will or whatever.
That was at that point.
He was not aware.
Okay.
Okay, so you are walking around and people are expecting you to perform your role, but you do not know.
Yes.
So here, somebody who is interested in the estate, okay, that's somebody who claims an interest. You must be a beneficiary or connected to it, can serve you notice through the necessary processes. Yes.
Exactly.
So when you now get that notice and you fail, so now when you get notice, you are the same place as the one who was at the reading and heard his or her
Yeah, that's
name.
true. Once
So
at a point, you're all aware.
yes. So now that you're aware, the days run, right?
Yes.
There's a required period stipulated within the rules of court within which you need to act.
Yes.
And in acting, it is not that you must come and play the role. You will now decide. Do I want to opt out, or I want to come and do the job?
If you don't want to do the job, there's a process.
Yes, you come and renounce it and say, I'm not a man.
I'm not interested.
You will not do it.
Yeah, I'm not
So if you, however, want to do it,
Yes.
then you follow the path.
That we've
apply.
already
To
talked
apply.
about, yes.
We already talked about it.
Yeah.
Now, when we talk about a job, somebody might say somewhere and say, oh, probably this could be a business. This job doesn't come with a salary.
No, it doesn't count as
You are
salary.
not allowed to take anything from this person's
Yes,
estate. Because somebody might be tempted to say, oh, it wouldn't be bad to go around availing myself for this role.
Yeah.
It's
Yes,
a
but-
non-paid
But
role.
I think that even beside the natural rule that you are not entitled to a salary or a pay as an executor, at least we are allowed to, the expenses that you incur
Yes,
in connection with the
the
application, the execution,
Yes.
all those are just debts.
Yeah,
that
but
the
that's to
estate
be
must
taken
bear.
from the estate.
From the
Yes.
estate.
But not your own personal allowance,
Personal
sitting
allowance.
allowance.
Yes, you can't do that.
Um, I was thinking about it, so I'm billing per hour.
You can't, and the
you
law-
You know,
the
if
law
you need
is-
to get a surveyor, for instance, that is
Surveyor.
somebody who needs to
Yeah,
pay
that
to
is-
help you transfer land.
land. If you need a valuer to value,
If you need a
if
lawyer
you need a lawyer, you pay.
to prove and help with the
Yeah,
processes.
his
You
legal
pay a
fees
legal
and
fees from the-
everything
from the estate,
comes from
but-
the estate.
So it shouldn't come at a cost to you, but then you shouldn't profit
No, you
from
can't
it
be-
as
you
well.
can't be paying yourself a salary or an allowance.
On somebody's.
On somebody.
If not, they'll just keep it going.
Yeah,
For
yeah,
10
yes,
years,
yes,
you
for
will
10
still.
years, yes.
Yes, and then I think when you look at the Administration of Estates Act, the law gives
A time frame
time
within
frame
which.
within which, as a named executor who has been granted probate, you should act.
You should act. So if
Of
you-
course, unless there are
But-
exceptional reasons
Reasons.
Why?
and nobody's challenging it.
Because if you leave it open-ended, people will administer properties for 10 to 20 years. And,
Well,
they-
it happens, especially
keep
where there's a
going.
challenge
that's true.
regarding some aspects.
Some aspects,
Yes.
that's true.
Then,
It could be.
or there's a legal suit connected to the estate. So somebody is suing the estate of the deceased
Yes.
person. As an executor, you have to be representing
Yes,
the
yes.
deceased.
Exactly.
So if that case travels 10 years, you stay in the role until then.
Exactly, but
Maybe the only thing is to distribute the aspects not touched by the litigation,
Yes.
and then hold on to the rest till
The
you're able
rest.
to find a
That's why
solution.
the law is clear that a month after litigation ends, you need to
Now do the needful.
Do the needful.
I want to believe this is a voluntary work,
Yes, it is.
which you have an option to opt out.
Yes.
As in the beginning, you've been given an option to either apply or renounce. I believe that those principles still apply throughout
You must consent to
tenure
the
of your
yeah.
execution.
Sure.
So if by some reason you feel this is not something you could continue by reason of maybe ill health, incapacitation, or the family is too complicated for you to continue, you have to give them notice that, hey, this is where the road ends for me. So, and it leads back to the beneficiaries who have to go to court for another person to be appointed to take over through an early with will annexed.
So let's also break that down because there are two scenarios at play. First person has been granted probate.
Yes.
Now, before you even distribute the estate, you haven't given out a needle to anybody. You decide that you will not proceed.
Yes.
Then you go to renounce it. Okay? You talked about the fact that you apply for letters of administration, this time with will annexed because there's a will.
Yeah, annexing the will.
So now it's administrators of estates who have to be agreed on, right? Like you need to agree on who now becomes administrators. Then let's talk about the second category because the treatment is the same, but the categories are different. The second person is the one who has administered the estates after grant of probate, and over the time, he's given some of the estates, some aspects out, but then there's this particular property that perhaps everybody is fighting over in a way that makes it almost impossible. They are challenging it, there's too much going on, and he decides that he no longer, or she will no longer be an executor.
Yeah.
Now, that's the residual part of the estate yet undistributed, okay, would be treated same as if it was the whole not distributed, right?
Yes, yes. So I think we've already spoken about it that probate can only be granted to named executors.
Yes.
So if for some reason the named executor is being excused or has resigned from his position
or has died,
the new person coming in cannot hold the authority of a probate. He can only hold he can only hold letters of administration with will annexed, so that his powers emanate from an early and also from a will, because there's in this scenario there's a will already there. There are times that people don't deposit these wills at the court because they might be oblivious about the requirement that it has to be.
That's why you need a lawyer again.
Exactly, my point always. So when a person passes on and you look to his personal effects and you find any testamentary document which says my property should be distributed so and so, the first step you should do is to deposit that document, whether you think it's just a mere paper or anything. You have to deposit it in the court and notify the beneficiaries that yes, now there's some sort of a will, if they will disprove it or they will allow it to go as a power that can, or a way that he intended that his property should be distributed.
So you have people who have renounced probate or by operation of law or society or nature have been removed. Maybe the person is very, very sick in a way that makes it impossible for he or she to play the role. Okay, and probably it's just one executor.
Yes, just one executor.
And the person is indisposed.
Yes.
There's nobody else to continue the job.
Yes.
Of course, that person can go appointing others, right?
Exactly.
So we talked about that, and then also those who have resigned,
Yes.
those who have died. And in that circumstance, we mentioned about applying for letters of administration with will annexed. Now, it is not automatic that any one of the beneficiaries can on their own go to court alone to apply.
Yes.
There are a group of people who can apply with will annexed.
Exactly.
And the law specifies specific people and gives priority to some category of people.
So when you look at the law, it arranges it from surviving children, because the needs of the children are very important. Then it comes to surviving spouse, if the person died leaving a better half. Then the parents, if at the time of his death his parents were still alive. Then finally, the customary successor. Usually people die and custom demands that you appoint somebody in the family to oversee his affairs in the family. So these are the category of people that the law envisages.
With that is the interstate succession law.
Yeah,
but where the person dies as an executor without finalizing his mandate, I think mostly the requirement is any specific legatee or devicee that the law is satisfied has a valid and tangible interest, and is entitled to a part of that estate.
Yes.
And then automatically these people he's listed will fall under that category.
So
and then you can
hierarchy,
yes,
the ones you mentioned, the specific legatees, they come first, and then he's
the other people, which be business partners or people that are even owed money. I mean, if
creditors could even
exactly, if the amount you're looking for will cover the rest of the estate, automatically you need to put in a stake. We sample people's opinion on the topic. Let's take a listen, and then when we come back, we comment on their comments with our own comments, and then we continue the convo.
Process that takes place when a person passes away. It involves proving and administering the person's will, and if there's no will, distributing the person's assets according to the law.
Probate is the legal process of administering a person or a deceased will or assets to the family. In my opinion, I think probate is designed in order to fulfill the wishes of the deceased. It is also to pay off the taxes or any debts that the deceased had when he or she was alive.
In my opinion, I think probate is the legal and financial way of dealing with the belongings of someone who is dead, or like the way that the people will determine if the will that the dead person or the deceased person was done correctly. That's how I understand probate.
Probate is the legal document one obtains so they could share a dead person's properties, estates, or like money or stuff like that. Yeah.
So when you talk about probate, I don't really know much about it, but I think it's a law term which defines a legal way of sharing or administering a deceased person property, or let's say a possession that person had.
Generally, I'm impressed that at least the general public, and looking at the survey, most of these people are very young. Like they know at least or have an idea about what probate and administration is all about. But I think there's a misconception. I think one of them said that probate is designed to fulfill the wishes of the testator, which is not correct. It's the will that is designed to fulfill your wishes after your death. But the probate gives the power to certain people to fulfill those wishes.
And also gives them the power to deal with institutions and entities.
exactly.
On your behalf.
If you have to collect somebody's estate and you need to go for their pension, SNIT benefits, you need to go for bank.
So even ascertain how much is in there.
Yeah,
Exactly.
accounts.
You need some authorization.
Yeah. So it's an authorization actually, which allows you to distribute and then administer the estate.
So it's a license
A
to
license.
collect,
So it's a license. Some
pay
even
just
called-
debts,
Some even describes a certificate which
Okay.
authorizes you
and
to
then
do
finally
To
distribute
distribute.
to the rightful
to the rightful
beneficiaries.
beneficiaries.
And there's regulation in even this whole process, because the fact that you've been granted probate doesn't mean there's nothing else after you've been given
Even
probate that regulates your conduct. And we've hinted on some of those
some of those things.
earlier on. So can we bring the conversation back to, we talked about where the applying for LA with will annexed.
Annexed, yes.
Great. So you are entitled to be granted, okay, LA,
Early.
by virtue of the hierarchy,
hierarchy.
and you refuse to, but also refuse to renounce that option. the law provides that the next person within the hierarchy can apply to take over the role, and same will be granted if there's evidence that you're neglecting your obligation. Now, you can be in line also and then decide that you don't want to do it at all by reason of probably you're still grieving, you're not in the right state of mind.
The stress of the
especially
process.
a surviving spouse.
The surviving spouse.
Exactly.
Yes.
And also where you are as child, a surviving child, and you have siblings who are competing, being in the position of power can bring more problems. So you can choose as a matter of principle
That I'm not
not
to be part of.
to go ahead to
six
apply.
of you and all of them want to be part of the process. And then you don't want to be part. I mean, you can decide. Yes, you're not being compelled. I mean, it's a right you have. You can choose not to exercise that right. I mean, that will not, if you are named as a beneficiary, it will not affect what you're entitled to under the law.
Let's talk about wills that are prepared on behalf of blind and illiterate testators. What are the things the law would consider in ascertaining whether indeed this is the person's will and testament?
Okay. So I think I will add one more person to the list as an illiterate. So you might be blind, but if you are also an illiterate, you form part of that pot.
Category.
Yes, that category. So the law requires that, you see, a will is a formal document which is being written or typed. So if the person cannot see or cannot read or has no formal education to understand what is going on, the law requires that you read to the person the content, and the person should understand and agree to the content. But that reading should on the face of the document, it should be there, that you read. It was read by this person on this date, and he or she understood before appending his or her signature.
Or thumbprinting or whatever.
Let's bring it to this place. When people say illiterate, the understanding is, some people think it's just about speaking English. Now, where the testator can write in Tree, in Dagari, in Hausa, in Ever, this is illiterate in that language and within that context.
Exactly.
Nothing stops you from preparing your will in the language you are comfortable with.
No, nothing stops you.
So that it's a personalized document, especially where you do not want other people to look at it beforehand. So you can write it in the language of your choosing, and then your witnesses will only attest to your signature.
That's it.
Unless you insist that it must be in English and you don't speak English.
You don't speak English, then that is when you are an illiterate.
Yes, then you are an illiterate within the context of that language. And whoever prepared that will is required by the law to read it over to your understanding. And it must be confirmed that this was your intention. And it matches with what you really asked that the person should prepare for you.
It's very interesting. I don't know if you've come across any will
in another language.
No, I haven't.
Not yet, unless it's from another jurisdiction.
But, you know, if you hadn't drawn my attention, right, I was assuming that
every will is in
supposed to
English.
be in English. But I mean,
there's no
law
requirement.
doesn't require that.
It's a personal document to the fact that you can have oral wills and all of that. But today is not a conversation for wills.
For wills.
But where you've prepared your will, you're allowed.
Yeah,
if you know that people can understand it
Yeah.
after your demise.
Yes.
You see, so if you are in Ghana, you go and write your will in Greek, in Greek because you lived in Greece along the line, there'll be more expenditure in translating, getting an interpreter, and even the issues of different varied opinions as to what you really wrote.
And our legal systems are different.
So it's not a matter of law but language. So you bring two interpreters and they see it differently. That becomes a problem.
That's true. That's true.
So how to go and have it translated, certified, mostly by the missions and all of that. It can be a long, and that's why people choose to do it in English.
That's true.
But I believe the bottom line is that if you are not literate in the language that the document is being prepared in, it should show on the face of the document that it was read to you and you understood before you signed.
The content, before execution.
Before execution. That's very important. It's time. If that's not done, that could be a ground
to challenge the validity
challenge the
of the will.
validity of the will.
So we'll go for another break. When we come back, we'll pick up from where we stopped. This is Law Express. Don't go away.
I think at this stage we should also talk about the wrapping up your duties as an executor. The law requires that within a period of time, say a year, you should have administered the estate of a disease. But at the end of administering, you have to give the beneficiaries what they are entitled to. And this is not just by word of mouth. You have to prepare a document and vest it, the said properties, in the named beneficiaries, which is called a vesting assent. But these are usually immovable properties.
So land, houses,
and
things like that.
Yeah. So your right as a beneficiary to a property, it doesn't just arise. You need to go through the process. When they vest it in you, it becomes yours.
So you're talking about your right to deal with the property
to deal exactly
legally.
Right to do
yes,
legally.
as a beneficiary.
Yeah, because you have a right always as a beneficiary.
Yeah, exactly.
But then you can't start dealing with the property, especially if you want to sell it.
If you want to sell it, for instance,
yes.
you can't go and sell a property when you don't have vesting assets.
Yes. Or change it into your name.
Unless, of course, you talk to the administrators to sell directly.
Yes,
because it's established that it's yours. They just haven't quite come around.
Yes.
You need money. So you can say, look, you know this house that is supposed to be mine,
yes.
which we all agree,
yes.
and there's no dispute.
Yes.
I'm selling it to Sebastian.
Yes.
So they will sell on your behalf.
Yes. So
okay.
in that instance, will they sell it in the name of the estate?
Like yes, because they are the reps of the deceased. The thing is still in the person's name.
Yes. So
I mean, it's just that because of the nature, it's to your benefit. And you haven't yet received it. So there should be some paperwork to cover them. If not, you will come back later to say, I didn't
know anything about it.
Yes. And would buyers be willing? If I am a buyer, I wouldn't want you to take that risk. I'd rather you...
go through the process.
Yes.
Because as a buyer, let's say, of a house, and you are aware that the actual owner is deceased, what you are supposed to look at, if there's a will, copy of the will, then the person who is attempting to sell to
not the will per se. You're not allowed to look at the copy of
maybe
the will.
The probate.
Yeah,
that's
the main enabling document.
You know, these days we do insist on the will.
But why are you looking into somebody's will? It's not your business.
It's not your business, right? But by way of due diligence.
Yes. But you shouldn't be
like
reading
you are selling
the will.
a property to me which emanates from a certain document. Because some people come for some reason and from anywhere, bring a document and say, I have
probate and then there's
Listen, when you are granted probate, automatically it indicates over whose estate.
Exactly.
It does.
Now, it also indicates when you were given that. So if the person comes to me, what I will be looking out for is that probate.
The probate. Okay.
Then you conduct a search on the property to check it against whose estate the person is administering. That should be satisfactory. But yes, some people, in order to convince you, are fast to whip out a will.
Yeah, they'll whip it out.
In my opinion,
you don't think
it's not necessary. Yes, it doesn't spoil anything.
Yes, it adds.
But what even shows that will is valid? Because you can also, confirm the validity of the will at that point on face value.
Yes,
so it's just too much.
I understand. But you see, the owner of the property is not alive.
Yes.
It's a beneficiary who is
claiming
interest and selling
document.
The court document,
yes,
mind you, it has names of the disease and the executors, and not the person who is purporting to sell the property to.
Mm-hmm.
So if you are named in the will, you are not on the probate.
But I was saying it within the context that beneficiary who is seeking to sell the property is not known to anybody in law. You still haven't taken the property yet.
Yes.
Yeah.
And the reason why we're expecting the executors to sell on your behalf is that if you go, you are a persona non grata. They shouldn't deal with you.
Yeah.
No law backs your
Yeah,
conduct.
and
So that's why I said that arrangement will be between the executors and the beneficiary, who have the will between them and have also heard it. At least, even if they haven't cited it, they've heard it when it was read,
Yeah,
right?
true, yes.
So you tell the executors that, look, I really need the money now. You haven't done this work, maybe because of 1, 2, 3, 4. There's no dispute, right? Can you sell on my behalf? So you are consenting to the sale. And that's why initially I was talking of paperwork.
Paperwork,
Yeah,
yes.
there's a need for
For
paperwork.
protection,
Yeah, for protection.
especially on the part of the executors,
The
because
executors.
they are selling on your behalf.
Yes.
And that's why I'm thinking if the executors are those dealing with the buyer
Yes.
and the other person is just agreeing
Then
on the
yes.
background, why should
Then
you
the
look at the
probate
will
will
of the
be-
deceased?
Yes.
Why should I look at it? Just
Yeah.
out of abundance of caution. I mean, it doesn't hurt.
No, for the purpose of disposing of the property, what comes to work is the probate or LA, where applicable.
Yeah.
And once you have that, okay, that's enough. You conduct your search. The name falls in place. Yes, this is the owner. He's dead. These are his lawful representatives. Then you buy from them. And nobody can contest that sale, even the beneficiaries, because it was legally and validly done. They can only sue the executors for diminishing the estates.
Yes.
Yeah. Because
Unless, of course, it was
third-party
before the
rights,
sale
yeah.
that they
Third-party,
found
yeah.
out,
Yes.
and then they stopped the sale.
Stop the sale,
But after
yeah.
it's passed and then the person bought it validly and legally, your action will be against them in their personal capacity,
You're just adding another level of
Yes.
which we
Due
didn't want to
diligence.
complicate.
It's due diligence.
Due diligence.
And that's why you should get a lawyer. Ask
Yeah,
Sebastian.
you need to get a lawyer. Sebastian is right. You always need to get a lawyer.
We have some questions from social media. Let's
Okay.
attempt to resolve them.
Dear Noella, I am Mama Jane from Oyarifa. My issue is that I have not been listed as a beneficiary in my deceased husband's will. I do not have a job and I am terminally ill. Is there any way I can be provided for from my deceased husband's estate? Let me also use this opportunity to commend you for this educative program.
She's taking us into a different arena.
Yeah.
But I think maybe to summarize it, I will say that if at the time of the deceased passing they were still married, then under the constitution she shall not be deprived of a reasonable portion of the
Well, it
estate.
depends on her need also. It's not really automatic, right?
Yes.
I mean, if you have so much and you are not in need
Yes,
per se,
yes, yes,
I mean,
yes,
You see, she's a spouse.
yes.
but the
Yeah,
person
she's not
intentionally,
independent.
I mean, what are the odds that somebody would forget his spouse or her spouse?
Okay, so let's look at it this way. What if the properties were acquired during the marriage?
But you are a spouse.
Yes. So
I mean, if it's established that the property is solely his, then it's part of his estate, unless you want to challenge ownership, where you're saying that you are not challenging the fact that you were not provided for, but you are challenging the fact that he
You
doesn't
are-
own all of the property he
Was
listed
acquired
there.
in the marriage and sold,
And you
so when I
contributed
claim, I
and you are a
contributed.
part
claim.
owner,
A part
and now he's put it in his will like it's just his.
Exactly.
That's a different leg.
Exactly.
Here, I think the idea is you being removed from the person's property. So maybe you are a housewife, you don't have a job, you've supported him,
dependent.
you're dependent on him. Then he comes to make his will, and maybe he found a new wife, maybe in a customary setting,
left
and he
you out.
decides that you'll be left behind.
Yeah.
He doesn't give you anything because he wasn't in love with you at the time
He-
he worked on it. Yeah,
worked
that
on it.
one, yeah, I think there's a cause because you don't have anything to rely on. And the law allows for the courts to make
intervene.
some provision, intervene, and also with
You
children,
have children, yeah, children.
yes, who have been left behind and not
They
catered
below the
for.
age of 18
Yeah, below the age of 18.
Yes,
So,
were
below-
dependent on him at
On
the time
them,
of his death.
yes. And then also people probably even older than 18, but who have some certain disability or
challenges.
Yeah.
challenges, I should say, and they haven't been catered for because they would require this to survive. So I'm looking at it within that context. But where you earn, you have money, you realize that, look, this was, what do they even call it? This was intentional. He didn't want you to get anything. You were actually eliminated.
And it could be proven that it is solely, the property was solely acquired by him.
So it's his property. He decides who gets it. Yeah. If he chooses to give all to charity too.
Yes. Yeah. There are people who give their property to their pets and all
that.
Yeah.
I've always wondered how that works. So the caregivers of those pets now handle it on behalf of the pets. It would be interesting to apply. The
trustees for the pets.
More like the pet wants to go on a holiday. So you need to travel with the pet's first class to that holiday.
So if you want to enjoy, just say the pet wants to go on holiday.
Must be nice. The pet wants to go on holiday with my family.
So I think our discussion has unraveled two solutions for her. So depending on the angle she's coming from, either you are saying that you're a co-owner, then which will require a different set of action, or you are saying that you are dependent on him, so a reasonable portion should be given to you because you have nothing and you are dependent. So I think she has the answers. And once again, she should consult a lawyer.
Yeah, that's his refrain. Consult a lawyer.
Very important.
In fact, he never adds near you. But that should have been part of it. Consult a lawyer near you. Or maybe a competent lawyer near you.
You know, even the physicians, they say consult a physician. They don't
where? So just find a lawyer.
Drugs, they will say, oh, you can't take this drug, but if it doesn't, consult
a physician. Not the nearest, no.
It doesn't matter how far,
No.
So we talked earlier on about the fact that somebody may renounce probate, may decide not to actually even go ahead with his job after grant of probate, may even decide not to apply for probate. And then we mentioned the fact that the law lists some people with tangible interest in the estate, or with interest in the estates in simple terms, who could apply or who are eligible to be granted LA with will annexed, right? So where that person next in line is a minor, okay, the law would allow for whoever is the guardian of that person to apply instead. But there's a caveat. That person only holds the estate, okay, and would only spend to the extent that it benefits this person, who is most likely to be a beneficiary, right?
Yes, most likely.
You can't go beyond those parameters. You can't spend on yourself. Anything you spend from that estate should be to the benefit and use of this person, this minor, until the person is 18 years and can either take over and properly apply. But then there are also minors sometimes who are made executors of wills. And if there's a sole executor?
So if a minor is named in a will as a sole executor, I think the court cannot grant the probate to that minor. It can either be granted to his guardian, or anybody the court deems fit.
Okay, so that will be, the guardian will be granted LA with will annexed as well. So that when the child attains full age, he can now apply for probate. But what that means is that they cannot distribute the estate.
Yes, from
the meaning of how the rules are.
That is the understanding that you cannot until the child attains the age of majority.
So the actual officer, legitimate officer, to do that job would have to do it. So perhaps you just be gathering the estate, doing maintenance, ensuring that it's in good shape.
You'll be a so-called watchman.
Like a receiver of some sort, right?
Of a sort.
Yes.
Or manager.
Corporate terms.
And the what do you call it? The obligations that come with that, you will have to abide by.
The rules,
the rules.
As a caretaker.
You don't have a free reign to do what you what you want to do. I think the idea of a child being an executor may look strange, or sound strange, but it's not.
It's possible.
If you have a 15-year-old child, and you don't see yourself dying anytime soon, with the idea that by the time I passed, my child would have
at least 18.
Majority would have been 18, and it so happens that maybe a year after you passed.
That's where this complication comes.
That's where this complication.
Now, some people would put people of different ages on as executors. Maybe one is 30, one is 40.
14, yes.
Now you die, and they have to work together.
Yes.
Synchronized conduct. Exactly. So how do you Will the courts approach this?
So that's what we're talking about. If there are two, if there's, what's the age of the
So one is 14, one is 30. So there's one
So
with the
30.
age of majority.
30 can go for probate.
Yes.
But the guardian of the 14-year-old would have to go if early will next.
No, because they are joint, as there are two executors. One will take it and probably behave like how the guardian would have acted, as a caretaker.
Then wait till
the
Yes.
the 14-year-old has attained
18
then probate will be
probate
granted
to be
to him.
granted to him.
as
Then
well.
they can complete the distribution.
Yes, yes.
Perfect.
Yeah, perfect.
I think we've come to a point where we can hang our boots today because we could never exhaust probate. It's a lot of material, a lot of technicality, a lot of angles to it. But like you know, Law Express is not to make people lawyers. This is not a law school. We just to educate, inform the public. And then if they need more information, they do what Sebastian suggests. Okay? See a lawyer.
This thing is rather technical.
Exactly.
So you need
And
lawyers to hold your hand and take you through.
yes, and your particular or peculiar situation would warrant some new angles to
be explored.
And you know, that's why once again it's important to take Sebastian's advice.
Exactly.
Always.
Every time. Always.
Always see your lawyer.
Viewers, my name is Noella Seidu. I was joined on the panel today by Enoch Sebastian Owusu and Yao Edinam Kofi. Thank you, gentlemen. This has been our show. Goodbye.